In this video, I'm going to talk about what is the Fifth Amendment right, where it applies and why it's important. And if you are a regular viewer of my channel, you might be wondering why I'm talking about this, but that will become clear later. If you are watching this from the United States, you might be wondering why I'm talking about this in an English accent, but that will become clear also. So if any of you are new to my channel, I'm an English barrister who helps you to understand law. And in some of my future videos, I'm going to help you to understand United States law as well. Because as barristers, we are often asked to research law in other jurisdictions, even though we are not qualified to practice there. I, for example, am qualified to practice in England and Wales, but I can, of course, comment upon law in other jurisdictions. So the Fifth Amendment is effectively a right to silence, but the full explanation is a little bit more nuanced than that. And in the United Kingdom, we effectively have a right to silence because we too do not have to say anything in criminal proceedings that might be used against us. First of all, the rights are referred to as the Fifth Amendment rights because they are the rights set out in the Fifth Amendment to the Constitution of the United States. A constitution being a body or a set of established rules and principles by which states are to be governed. There are 33 constitutional amendments in total that have been ratified by Congress and sent to the states for ratification since 1789, although only 27 of these were in fact ratified and became part of the United States Constitution. So whilst you might think of Fifth Amendment rights as a right to silence, formally or legally it is a privilege against self-incrimination. It effectively gives every individual the absolute right to refuse to answer any questions and refuse to make any statements that may be used in criminal proceedings to establish that the person was guilty of a criminal offence. Very important to note that the Fifth Amendment can only be invoked by individuals and not corporations or any other business entity. A well-known principle established in Braswell and the United States of 1988. But what many people don't know is that the Fifth Amendment rights can not only be invoked in criminal proceedings and investigations, but also civil proceedings, administrative hearings, and any other kind of formal or informal investigation of any kind. This was a more recent principle established in United States and Balsys of 1998. So having established and explained that there's an absolute right to silence in the United States, regardless of the type of proceeding, civil, criminal, administrative, and in any kind of investigation, whether it's formal or informal, I'm going to talk a little bit about how it works in England and Wales and how it might differ, because this is the source of a lot of confusion, both for those in the United States that might visit England and Wales and believe that there is an exact equivalent, or people of England and Wales who believe there's an exact equivalent of the Fifth Amendment rights and misunderstand how it might apply, particularly in respect of a criminal trial. It may be a useful starting point to compare the police caution in the United States as against that used in England and Wales. In the United States, the caution is generally a variation of the following. You have the right to remain silent and refuse to answer any questions. Anything you say may be used against you in a court of law. You have the right to an attorney. And if you cannot afford an attorney, one will appoint it for you before you answer any questions if you wish. So effectively, this caution is saying that the individual has an absolute right to say nothing, but anything they do say may be given in evidence against them, and they have the right to legal advice before questioning. Comparing that with the caution in England and Wales, which is as follows. You do not have to say anything, but it may harm your defence if you do not mention when questioned something you later rely on in court. Anything you do say may be given in evidence. So whilst this caution is similar in that it tells the suspect that they do not have to say anything, i.e. they are not compelled to say anything to incriminate themselves, the caution comes along with a warning. This warning is that it may harm their defence if they do not mention, when questioned, something that later on they use in court in their defence. In other words, if it's something that they could have known and should have said at that very moment, and they don't say it, but they say it later, there may well be an adverse inference drawn. And this is something I'm going to discuss throughout this video. So to highlight this difference between the United States and England and Wales, I'm going to refer to the principle set out in the United States case of Griffin and California way back in 1965. This principle is that in a criminal case in the United States, a jury is not permitted to draw an inference of guilt from a defendant's refusal or failure to testify or to give evidence on their own behalf. And to put this in simple terms, it means that the jury member is not allowed to conclude that the defendant is guilty of the offences charged just because he or she did not give any evidence. Now to contrast that position with how it works in England and Wales. Whilst in a criminal trial in England and Wales, a jury is not permitted to convict a defendant solely on the basis that they failed to give evidence. They are permitted to draw what's known as an adverse inference. This means that a jury member is permitted to draw some kind of adverse or negative inference against the defendant if the defendant refuses to provide any evidence in court in their defence. And this principle runs right from the moment they are arrested, right through to when they are interviewed, and through to when they are put on trial for the offence. Thinking back to the police caution I mentioned a moment ago, the police caution will say that whilst they do not have to say anything, it may harm their defence if they do not mention at that time something that they then later rely on in court. And this is effectively giving the suspect a warning at the earliest opportunity on arrest that if they do not mention something at that point, that the jury may later draw an adverse inference in respect of their guilt. Whilst they cannot convict a defendant solely upon their silence, it will be part of the equation. So whilst weighing up all of the evidence, the jury will be allowed to consider the fact that the defendant did not give any evidence on their own behalf. So just to highlight that difference again, in criminal cases in the United States, a defendant can invoke his Fifth Amendment rights to silence, and the jury is not permitted to draw an adverse inference as to his guilt. Whereas in England and Wales, if that defendant has been cautioned at the outset and has remained silent and then does not give evidence in court, a jury in England and Wales may indeed draw an adverse inference as to that defendant's guilt. Although they may not convict solely upon that person's silence, it will be considered as one of the factors. And similarly, contrasting the cautions, in the United States, that segment of the caution is you have the right to remain silent. It's absolute and it is unequivocal. But in England and Wales, that part of the caution forms most of the caution. You do not have to say anything, but it may harm your defence if you do not mention when questioned something you later rely on in court. And so for the interest of our United States viewers and the information of our England and Wales viewers, this can be found set out in the Criminal Justice and Public Order Act of 1994, sections 34 to 38, briefly as follows. Section 34 provides that the effect of an accused's failure to mention facts when questioned or charged, when in any proceedings for an offence at any time before he was charged with the offence, being questioned under caution by a constable, failed to mention any fact relied on in his defence in those proceedings, the judge and the court may consider that fact when determining whether there's a case to answer, and the court or the jury, in determining whether the accused is guilty of the offence as charged, may draw such inferences from the failure as appear proper. Similarly, in section 35, if the defendant refuses to give evidence at trial, the court or jury, in determining whether the accused is guilty of the offence charged, may draw such inferences as appear proper from the failure of the accused to give evidence or his refusal without good cause to answer any question. Although it does clarify that the failure to do so would not render the accused compellable or guilty of contempt of court. One important clarification, however, in the United States is that in a civil case, a jury or administrative body is permitted to draw an adverse inference against a party who refuses to testify against evidence offered against him. In England and Wales, it is a little bit more evidence-based. A defendant is required to provide evidence to rebut the case against him, and if he fails to provide such evidence, whilst the court may still find the case not proven, there will of course be no evidence to rebut the claim if the claimant brings evidence to court. So I hope that serves to be a useful explanation for our United States viewers and of interest to our viewers from England and Wales who are interested in the difference between the two. So please do like this video if you found it useful, and remember, stay humble and subscribe.